In this presentation, we will discuss criminal law. At the end of this presentation, we will be able to describe and discuss what criminal law is, list classes of crimes, identify mental states in the criminal code, discuss corporate criminal law and liability. When considering criminal law, the main objective will be to protect the public. So we want to put laws in place, enforce laws in order to protect the public. How are we going to be able to do that? We can define what things are going to be not good or against the law for the public. We need to enforce those things for a few different reasons. One, to discourage things that are going to be not good for the public. And these are typically going to be things that will be harmful not only to the individual but to others within society, and therefore be harmful to society as a whole. If individuals are doing things that are harmful to society, then we want to make sure that the punishment involved will either remove them from society if it has to be done so, or will be sufficient enough in order to deteriorate or reduce the likelihood of things that are harmful to society to happen. Given the fact that a crime is something against the public, it's basically the idea that there's going to be something that's threatening the safety of people or the peace or well-being of a community. It is important that there could be and often is overlap between tort law and criminal law. In other words, one act could both be a violation of criminal law and tort law. The objectives then being different. Under the criminal law, there is a problem with regard to society. The act was against the well-being of society and therefore in the realm of criminal law. But it is quite possible that that act also had negative consequences towards other individuals, and those other individuals could seek to get remedy for those under tort law. It's important to note that there is a concept of double jeopardy, that concept being that an individual or party cannot be tried twice for the same crime. However, this doesn't apply to the case where we have the criminal case and then could have a similar tort case brought up for an individual or defendant. Part of the reason that double jeopardy does not apply in this case is that the objective for a criminal case and the objective for a tort case are going to be different, in that the criminal case, the requirement is that the defendant be found guilty of a crime beyond a reasonable doubt. But for a tort case, the defendant is liable for the tort by a preponderance of the evidence. So there's going to be a slight difference in terms of what the goal is to seek in order to seek prosecution or be found guilty in terms of a criminal case versus a tort case. Victims typically have rights within criminal cases as well, and those rights will typically include the notification that the offender has been arrested, giving the criminal defendant name, saying whether there is eligibility for pretrial release of the defendant, telephone number of the law enforcement agency responsible for the caretaking of the defendant, and the date and the time when the defendant's release will be. Criminal law is typically something that will be left to the states in order to fund the state police and create the criminal law. However, the federal government does enact criminal law and has the Federal Bureau of Investigation, the FBI, which is basically a national police force. We could categorize crimes by level of seriousness. For example, treason, felonies, and then misdemeanors. A felony is something that could be punishable by death or imprisonment. Some examples of a felony could be something like an armed robbery or manslaughter. A misdemeanor is going to be something that's less serious of a crime, and of course then the punishments would be less in order to comply with the less serious crime. General punishment of prison sentence of not more than a year. So a felony typically, if we have a prison sentence, will typically be over the year. Misdemeanor, typically prison sentence under a year. Example of a misdemeanor would be something like disorderly conduct or traffic violations. It's important to note that it's not just the criminal act that needs to be in place in order to have criminal liability, but also a factor involving the state of mind. The state of mind itself cannot generally require or constitute a criminal act, so thinking about a crime will typically not be enough in order to be convicted of a crime. We need both the criminal act and the intention, or some form of state of mind during that process. For example, drinking and driving would be a crime if we had both the driving, incurring, and the state of mind being one which is intoxicated. There are generally 4 states of mind to consider when considering the state of mind as it relates to criminal activity, those being purpose, recklessness, knowledge, and negligence. Purpose means that the individual acted with the purpose, the intention of having the outcome that happened. So they knew the outcome, they planned the outcome, they had the purpose of the outcome as their mindset. Knowledge would typically mean that the person that has the action has knowledge or has a reasonable knowledge that the outcome will be what the outcome will be. And so they know what the outcome will be, even if we perhaps aren't intentionally planning for that outcome. Recklessness is the idea that people have a disregard for the likely outcome. So if we're acting recklessly, we probably have a very good knowledge that there is a fairly high chance of a negative result to be happening from the behavior, and therefore we have the recklessness mindset in that we're perceiving or continuing with behavior when we know it could have a high risk of negative consequences, such as someone being injured or killed. Negligence is going to be a mindset in which an individual is acting in such a way that they just aren't aware of the potential risks. They're going to be participating in something that could have a negative outcome, and they are unaware. Their mindset is unaware of that negative outcome, therefore they're acting in a negligent way. When considering criminal cases, we often hear the term motive, and the idea of the motive is going to be the reason for the act, the reason for the wrongdoer committing the act. It's important to note that we haven't listed motive in the mindset, the mindset for being convicted of a criminal activity. It's not required to have a motive in order to be convicted of a criminal activity, the criminal act being something that has a mindset and that has a negative outcome or is a crime against society in general. A motive, however, might help the situation if we can determine a motive that would lead to the criminal act that could be good evidence leading towards what we would be thinking as a conviction or a reason for the criminal act, or a reason for us to believe that the mindset necessary to be convicted of a criminal act is indeed there. When considering a criminal act as we've defined it so far, it applies very well to an individual. We have to have an actual act, a criminal act, and we have to have a mindset. But it gets a little bit more confusing when we apply this definition to a corporation. We still can have that criminal act, but the mindset is a bit more confusing. In order to understand this, we of course need to understand what is a corporation. And a corporation is going to be a separate legal entity. So the corporation is an entity into itself. So when a corporation commits a criminal act, we're not really saying it's an individual committing the act. We're saying it's a corporation. We've given the corporation some rights as we would individual rights. That has the right to be able basically to own property and certain other types of rights, which we typically only think of as rights to individuals, including even a right to life, liberty, and property for the corporation. And therefore, the corporation can also be sued. We can sue this entity, this thing that has these characteristics that we are attributing to the entity as we would an individual. So that means the corporation itself is not one individual. It doesn't have a mind in itself. We can't really say what's the mindset of a corporation, because the corporation is really a conglomerate of individuals making decisions within the corporation. So how do we set up that mindset type of state? We're going to basically be saying that if someone within the corporation acting as an employee in the corporation, acting as a decision maker in the corporation, acting in a way as an agent of the corporation, supposedly doing what is best for the corporation or applying assets or making decisions on behalf of the corporation, does something that is a criminal act, we can then apply that to the corporation. That would be a justification for a criminal act of the corporation itself. When considering the punishment for crimes, we want to remember what the purpose of the criminal law will be, and that's really to safeguard the public. So when considering what the consequences will be, we want to define or make the law in such a way that it will achieve those goals. So in one sense, we want to make sure that the crime or the punishment will, in a way, fit the crime. That's an appropriate punishment to fit the crime. And this will help society in general because they will see that hopefully there's some consistency. They'll see that there's some fairness. It's really important in order to have some fairness in the legal system so people have confidence in the legal system. We also want to have some consistency so that people can know what to be expected. We need to know what the rules are in some degree or in some way in order to act in accordance to be in alignment with society so everybody can move along with everything they need to do. We also need to make sure that there's a deterrence factor within the law, and that's going to mean that it's clear that the law is not going to be able to catch every criminal, and our legal system, of course, is designed so that we don't want to punish someone who was innocent. So we're leaning towards within the law to actually not punish someone who is going to be innocent, which means that we're more likely to let go people that are actually guilty. We would rather have it that way. We would rather let go people that are guilty than punish someone who is innocent. And that means that, of course, there's going to be many types of consequences where people break the law and they're not going to be caught. And what we have to do on the deterrence side is make the punishment high enough so that the risk of being caught to a reasonable person would be high enough so that they would not commit the crime. For example, if we were to drive in the carpool lane with only one individual in the carpool lane, violating the rule that you need more than one person in the carpool lane, if we did that every day, we may only get caught once every month or once every couple months. But we're still not going to do it because even if we had no regard for the fact or for the reasons of the carpool lane, if we have no regard for that, we would still not do it if we were just self-interested, because the punishment of the fine and other tickets or other consequences of being in the carpool lane would be high enough for us to not get the benefit of being in the carpool lane for that time period. So that's going to be one type of deterring aspect of the law. We need to be able to create the punishment, one that fits the crime, two that's high enough to deter the crime, even though the likelihood of being caught for many crimes will not be high on an individual by individual state. But as time passes, it's more likely, and as crime continues, it's more likely that someone would be caught for a particular crime. We also, of course, want to remove individuals from a society who are going to have negative consequences either to society in general or to others within the society. And that would be things like taking people out of the society either through imprisonment or through things like the death penalty. A list of crimes against people would include things like assault, which would be a threat of harm, as opposed to battery, which would be actual physical harm to a victim. Things like murder and manslaughter. First-degree murder has aggravated and premeditated intent within the murder. And when we talk about manslaughter, we're talking about death, but the premeditated intent is not necessarily there or not proven. This, of course, is another area where mindset is very important here. When we talk about murder versus manslaughter, there's a big difference between those two in terms of punishments. And note that the outcome could still be the same. For example, if someone got hit by a car and they died, a pedestrian got hit by the car and they died, there's a big difference as to whether, one, it was an intentional running over of an individual, which would be murder, be premeditated, and would be of a higher penalty than if it was manslaughter and unintended. You would have a much different consequence in terms of what the penalty would be. Note the consequence to the individual, the person who was hit, is the same. So it's important to note that intention plays a big role in many areas of the law, and this is one area where it's very distinct. We can see it very clearly. Even though the outcome is the same, the mindset, if it can be proven one way or the other, will make a big difference in terms of what the penalty and punishments imposed will be. Crimes against property include burglary, breaking and entering, and trespass. Burglary is going to be the idea of someone forcing an entry or through deceit a trespass into an occupied structure with the intent of to commit a crime. If we add to that a weapon involved in the burglary, we then have aggravated burglary. And breaking and entering is the idea of using either force or deceit in order to trespass, in order to commit a theft or any kind of felony. The crime of arson involves the burning of someone's home. The crime of theft involves the taking of someone's property without that individual's consent. And then we have the concept of fraud. And fraud's another interesting example because it does involve some type of intent and it involves some type of deceit in order to obtain property or services that don't belong to the individual. So that's another example where when we talk about fraud, we would need to prove then the reasons for the fraud, the act that was being perpetrated, had the intention of committing some kind of deceit in order for the individual to receive type of personal gain. Note that that often is going to be the difficult component to proving fraud. It is difficult to prove what's in someone's mind, the intention. So that's going to be the component that would need to be differentiated in order to prove a case of fraud. Crimes involving a business typically involve things like embezzlement, forgery, or some type of defrauding of creditors from the business. So embezzlement is going to be something where there is a taking of the assets, usually often by an employee, someone who has authority on a business perspective in order to act as an agent of the business, then taking resources from the business. Other types of crimes that we could say crimes are against justice include things like intimidation, bribery, and theft if we are in office. Dereliction of duty are going to be other types of crimes. Bribery, of course, involves the offering or a promise for something to a public official in order to receive something in return. The dereliction of duty is going to involve something like if we were talking about a law enforcement officer who doesn't comply or achieve the duties that would be expected in a certain situation, we would say that they were derelict of duties. Intimidation would be a threat of some kind. So if we have a threat to a public servant or official in order to have to coerce them to receive something of benefit, that would be some type of intimidation. We also have obstruction of justice as another component of a crime, which would be the act to prevent anything that we do in order to prevent the discovery, apprehension, arrest, prosecution, conviction, or punishment of any criminal defendant. Resisting arrest, perjury, and tampering with evidence are going to be some other examples of crime. Perjury being the making of false documents. So if we have false documents under oath, that's going to be the concept of perjury. We also have the concept of a cyber trespass, and that's going to be the deliberate access to a computer without authority with the intent to commit a crime. Other crimes involving computers include things like cyber harassment or cyber stalking. Cyber extortion is when an individual gains access to a computer and finds something that could be of a problem to the individual involved, something like an illegal act. If they have information of an illegal act, negligence, something that's an unethical act, or just something that's going to be an embarrassment to the individual and then could damage the reputation of the individual, that would be cyber extortion. Cyber crimes also include phishing type crimes, and that's going to be the idea of sending out emails or some type of information in order to obtain information in order to get access. So basically the idea being that you're sending out someone to pretend to be something you are not in order for the individual to then respond and give information for something that is really not true. So they're looking to gain things like account numbers, possibly PIN numbers, possibly codes or access codes to online sites such as banking sites, or even any other site that they can continually gather information on and use for whatever purposes. The concept of cyber spoofing is going to be the idea of someone falsifying their identity by gaining access to someone else's computer to get a different identity in order then to commit some kind of crime, some kind of fraud. The idea of cyber terrorism is the use of a computer in order to gain access so that the intent would be to disrupt a nation's, typically a nation's infrastructure in some way, just to basically to cause harm to the nation's infrastructure. Cyber vandalism is going to be different than something like a phishing attack, in that a phishing attack is really used in order to gain information for later use, where the cyber vandalism is usually typically designed to just destroy something. They just want to destroy the system so that it can no longer be used. And typically cyber vandalism may not have any real intent in terms of gain. It might just be something that would be vandalism intent, just to destroy something. When considering a defense against a criminal act, how can we defend against criminal liability? We need to first look at those two components again. We have a criminal act and the mindset. So we have to disprove one of those two in order to have a defense. And one area, of course, is going to be the mindset. So we could try to prove something like insanity in order to disprove that mindset factor, and that would be one form of defense for criminal defense. Entrapment would be another defense for criminal liability. The idea of entrapment would be that the law or the breaking of the law was caused by law enforcement to induce the crime to happen. In other words, if it wasn't for the intervention of the law enforcement in some way, then the crime would not have happened. That could be some type of grounds for an entrapment defense. A defense related to justifiable force would be something like the self-defense defense, or a defense of others if the criminal act, or the charge on the criminal act was one in terms of self-defense or the defense of others. These could be defenses for criminal liability. For more accounting information and accounting courses, visit our website at accountinginstruction.info.